Let's get to work. Let's see what's going on here. All right, let's start with this Little Durk update. So he's kind of got, like I mentioned earlier in the intro, some good and some bad news in the two separate cases. So everybody's been paying attention to his bond. Will he get bail, provided that him and the feds have been going, or the government's been going back and forth as it relates to that song? The fan added audio. Did that happen before or after the shooting? So follow up to his bail situation, he asked for more time to prep for how they gave him that superseding indictment and they removed the lyrics from his paperwork. That was a chess move and a half. But all right, here we go. United States District Court, Central District, California. Defendant Dirks Banks reply in support of his application for reconsideration of detention order. All right, so this is his attorneys coming back saying, listen, this is the reason why you need to reconsider us for bail. All right. On December 12th, 2024, the court held a detention hearing and ultimately ordered that Mr. Banks be detained based on two factors: danger of flight risk. On the issue of danger, the court relied primarily on facts presented in the first superseding indictment. The issue of flight risk, this court admitted, was a closer call. As the court is aware, the probation department assessed that Mr. Banks was not a flight risk, but did recommend detention based on the dangerousness. So, if you remember when they came back uh, on the government side, they said he didn't even address the flight stuff. Well, they're being smarter this time around and saying, no, 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 no. As far as the flight stuff, he was already categorized for that. All right. And we do admit that we understand that in this particular case, you see some danger in that. But we came back, we had it assessed. You guys still went that direction, but we have new evidence, new discussions that we're bringing to the table. The flight part of it, we want reconsideration for. All right. So I understand them coming back with that. At least it feels like it wasn't skipped the first time, because that would have been just a miss on his lawyer. Since that hearing, the landscape has shifted. On May 1st, 2025, the government filed a second superseding indictment, which removed two major allegations from the first superseding indictment. First, First, it removed the allegation that Mr. Banks' song lyrics somehow glorified the murder of SR. And second, it removed the allegation that Mr. Banks directed others to pay or be paid a bounty for the murder. Important. How do you remove that? Like, how does the government remove? Is this not a murder for hire case? So how do you remove that? Banks directed others to pay or be paid a bounty for the murder. Well, I guess if they're removing that, what's the backdrop? I mean, we have yet to see what's going to be presented at trial, but what's the backdrop? That he didn't pay for it. It was just retaliation, slap of on type shit. There's sayings that, if it's really a loved one, you shouldn't have to be paid for it, right? Do they got lyrics about that? I don't remember. I'll leave that there. But I guess that's the only backdrop if you're gonna remove that and saying, all right, we're not sure if he paid for it. Because damn sure don't have no proof then. Because if you have proof that he paid for this shit, it would be plastered all over his last indictment, the original indictment, everywhere, right? Banks directed others to pay or be paid a bounty for the murder. Importantly, the government returned to the grand jury and sought the second superseding indictment after. And apparently, in response to Mr. Banks filing his motion to dismiss the indictment and his application for reconsideration of the detention order, in essence, the government effectively conceded Mr. Banks' central argument in his application for reconsideration, that the government presented false or misleading information about Mr. Banks to the grand jury and to the court concerning critical factual allegations. Well, I don't see in the paperwork that the government flat out said that they conceded, but it's almost a common sense thing to me. It's kind of like the domino effect, right? They came for their original reconsideration and they said, yeah, the song that you guys are basing all this and you took the grand jury, those lyrics wasn't, or the song as far as the Quando's no, no from the news clip being inserted into the track, that's fan made. And we got proof and evidence that we're presenting for that. We got witnesses that are signing off on this, engineers, people that featured on the song, all that. So if you now come back with a superseding indictment and you take that out, yeah, that's conceding, like, huh? Or forget about that. We don't want to talk about that no more. So I think his lawyer did a good job right here, because that was big, because you're trying to prove that not only did you were you involved in this alleged murder for hire, right? But then you bragged about it, and the bragging is deeper than just bragging. That the bragging leads into a mission of guilt. That's basically what they're trying to say is you're telling on yourself in these songs, right? But those lyrics and those songs, they came with evidence in their defense. In its response and supplemental filing, the government downplays these changes as immaterial and undeserving of the court's consideration. However, as detailed below, they are both appropriate and a great import in the court's review of the statutory factors for release. With the issues of the lyrics and the payout of a bounty altogether abandoned. Yeah, man, they left that alone, huh? What remains of the indictment is a weak patchwork of unsupported and non-specific allegations against Mr. Banks. This watered down new indictment, coupled with the robust bond package proposed here, tips the balance in favor of Mr. Banks. Release pending trial. That write-up sounds. They did the thing right there. His lawyer's at work. I'm seeing him doing interviews. He's moving around. I just see him on DJ Vlad. He was on DJ Academics. Who is it? Drew Finling. I'm glad that despite him moving around and interviewing and being all, you know what I'm saying, out there publicly accessible, behind the scenes, court wise, legal wise, process wise, he's doing his thing. All right. The argument. The weight of the evidence has changed since the initial detention order. So we pretty much just read that. First, the second superseding indictment removed paragraph 6 of introductory allegations in the first superseding indictment, which relied on lyrics from a song to allege that Mr. Banks was somehow celebrating or commercially glorifying the death of SR. Yep. All right. So that was a good one. To be clear, the inclusion of the now removed portion referencing song lyrics was more than immaterial fluff in the first superseding indictment. The government absolutely intended that section to illustrate direct involvement in the alleged murder for hire, and more importantly, the knowledge of Mr. Banks of the alleged offense through some sort of musical confession. We just said that. Yeah, so we was on point there. And yeah, it's not just the telling of yourself, but even if, let's say, Durk as the money man, Durk as the face, Durk as the leader, you're saying this is a murder for hire, right? So even if you don't put him at the scene of the crime, right? You could take the lyrics and say you're still connected to this because you're bragging about it. So you're linked to the people that actually did the shooting. I get it. I get it. Makes a lot of sense for his lawyer to be coming with this angle right here. Of equal or even greater import, the second superseding indictment removed paragraph 9 of the original indictment, which alleged that Mr. Banks directed others to pay a bounty for the killing of SR. This material change also significantly impacts the court's calculation, as this court in the initial detention hearing specifically cited the government's allegation that Banks exercised control of others and that other people acted at his direction to find dangerousness. Yeah, shot calling. Shot calling. I ain't gonna lie. When we read that superseding indictment, I said they playing dirty the way they just pulled that move while he was in the middle of his bond review. But they here to win, right? The fucking feds, man. Sheesh. All right. Now that the payment of the bounty allegation withdrawn from the indictment, the foundation for this court's conclusions has been materially undercut. Okay, what's this? Alleged have been sent by Mr. Banks. No other specific direct evidence has been provided to date, including any evidence showing Mr. Banks' alleged control of others. The government continually refers to in the previous indictments and in their arguments before this court. So that right there, to me, you know what that means? Yeah, you got a shooting. It's on camera. You have a murder. You have a deceased young man there, SR, right? Regardless of if you indict anybody in this case, because remember, there's 5 OTF members that were indicted even before Banks or Durk, right? If you indict anybody behind this, whether you can prove that, you know, Didi or this person over there was the one that was behind that mask at the gas station and is one of the shooters, you're still separating Durk. That's what his lawyer just did right there. That's not no ratting shit. He's just separating them, saying that regardless of what you do with whatever shooters you bring charges against or you convict, You have no proof or evidence that I'm tied to anybody as of these actions. Now, if we start seeing them throwing his codees under the bus and naming them and saying, "Oh, what," then we'll interpret that, as if that ever happens. But you know what happens in this case then? If you don't have the evidence tying him to those actions, even if you can tie him to those people, like you got songs with some of those people that are in our custody that we convicted. Like, let's say some of those convictions happened before Dirk, right? While he's still fighting his case, other people plead out or get convicted, whatever the case may be. What his lawyer's separation does right there, it does protect him, and then that just makes everybody got to stand tall. It makes everybody got to stand tall. It's the whole, we went as 5 people, we robbed the bank. Person number 3 got caught, and person number 3 don't know nothing about the other 4 people. If you get caught in this scenario, you got to stand it. Everybody else, if the people that got away, ain't no damn, yo, we caught. No, we not caught. You caught. Yes, I'm the one that paid. Or yeah, I'm the one that gave the order. Oh yeah, I was the first one that hopped out the truck. But you're the one that got caught. So everybody just got to stand tall. Everybody got to stand on their shit. You know? Wow. Okay. So I mean, tactically, I understand that move by the lawyer. While it is true that the second superseding indictment also added additional charge of stalking, the addition is immaterial to the question of detention, as the allegation already existed in the first superseding indictment. So here's the thing about the stalking charge that they added. Wouldn't you still have to place Lil Durk or have evidence or proof that he was in one of those 2 cars? Because you had the striker and you had like the tail, so to speak, right? At least from the stoplight footage and some of the camera footage that we've seen so far in the pictures, right? So you would still have to put him in one of those cars, right? Or you would have to put him in locations around Quando Rondo, like saying like, here's footage or evidence that Dirk and his team pulled up to the hotel at first. They didn't find Quando there. And then there's evidence of them now tailing Quando Rondo. Dirk is in that truck. To me, that's the stalking stuff, right? Which then led to a death, right? So if you put him in the second car and you say that he didn't hop out, nobody in his car was shooting, but the other car hopped out, and it looks like they're together. I see how you could put that together and still catch charges on Dirk for that. But you would need the evidence, no? Like where's the proof of Dirk was stalking Quando Rondo? Did he fly in on his private jet? Looks so. Right? Was he there the weekend or the day of? Looks so. Did he leave shortly after? Looks so. But where's the evidence that places him stalking Quando? His lawyers tearing this apart a little. Well, I shouldn't say tearing it apart. The feds, they did their thing too, but he's put up a good argument. Reasonable conditions exist to secure the safety of the community and any concern regarding risk of flight. Mr. Banks has filed a robust bond package which outlines a variety of conditions to secure the safety of the community and ensure that Mr. Banks complies with all conditions imposed by this court. One of the conditions that Mr. Banks proposed was the use of a 24/7 licensed security company. There's an exhibit for this as well that we're going to get to. This court expressed concern that the presence of a security company providing security for the defendant is not going to address the significant concerns with regard to the safety of the community here. Once again, they got an exhibit for that. Give me a second. The security company would be acting at the direction and under the guidance of the defendant. The government argued that the security would be present for the physical protection of Mr. Banks. All right. To clarify, the purpose of the security company detailed in the bond package would be to enforce the terms and conditions of the bond set by the court. Would they be picking up that responsibility? Really? Specifically, if there is an order regarding curfew or home confinement, the security company would serve as a whatever that is, a measure to ensure Mr. Banks' compliance with those conditions. Put another way, the security company would be beholden to this court, not Mr. Banks. Okay. So you're saying that they would be on the hook with the court. They wouldn't just be his personal guards in detail. That's just like any other security guards. They bring you the weed. They do what you say. Like I'm reading it. It's like, if I go higher security, what loyalty do they have to the court? Like, they're gonna be like, "Yo, hey, we got to get you home by 8 o'clock for your curfew, nigga. You work for me." But you're trying to put them on the hook with the court instead of me. Okay, all right. Specific plan regarding the line of communication to the court. All right. Yeah, you want them to work directly. All right. So Dirk gonna pay that security company a nice amount to put themselves out there like that, I would assume. Conclusion. Whereof, based on the change of circumstances created by the second superseding indictment, as well as the significant bond package that includes stringent conditions that would properly rebut the presumption that he is a danger or a flight risk, Mr. Banks respectfully requests this court release him on conditions pending trial. All right. So that's the update as far as his response to the reconsideration for bond. Now let's look at that exhibit as it pertains to the security detail real quick. Let's take a look at that. All right, exhibit B. So this is the security detail. RSEC Group Security Services, and they write, dear honorable judge, I hope this letter finds you well. I am writing you in response to the concerns regarding the potential risks associated with allowing a high profile individual to have the freedom of movement while under bond. I like that they didn't put Little Dirk's name there. They just put a high profile individual, as if that's the type of detail that they're used to doing. Like, we're experienced in this high profile. It's not about Little Dirk. As an established security agency with experience in residential security, I would like to outline the processes and procedures that can be implemented to ensure the compliance with any court ordered restrictions for this individual. Oh, yeah, they going in. This is a nice proposal. Number one, clear protocol development. Before assuming the responsibility of security, we will work closely with relevant legal authorities, including your court, to understand the specific restrictions imposed. This will include a comprehensive review of any limitations on movement, communication, or interactions. They going in. I ain't gonna lie. Number two, access control. The security team will manage access to the residence, ensuring that only authorized individuals are permitted entry. We can implement visitor logs, ID verification processes, and restricted access within the property to maintain a controlled environment. Number three, surveillance measures. Security cameras and monitoring systems within and around the property will allow for real-time oversight. Recorded footage can serve as documentation to support compliance with the court's directives. So if you don't got cameras there, Dirk, we installed them bitches, and the court's got access to them cameras and that footage whenever they want. Is that not giving up a little bit of your freedom that has nothing to do with I don't know. Because even if you release me to house arrest, right? I've never heard of house arrest requiring recording devices that the court has access to while I'm in my home on house arrest or on the ankle monitor or something like that. And all right. Regular reporting. Our security personnel will provide regular reports detailing the activities of the individual, including any suspicious behaviors. You're saying basically we work for you. We'll tell on Dirk. If we see anything suspicious, somebody that comes by that's not supposed to be there, a phone call that he has that sound a little shaky, we're gonna let you know. I don't believe y'all, but all right. Number five, incident response protocol. In the event that the individual attempts to violate any restrictions, our team is trained to follow specific response protocol. This would include documenting the incident thoroughly, notifying law enforcement if necessary, and immediately informing the court or authority of any violations observed. In conclusion, our company is prepared to implement these recommendations and establish a cooperative relationship with the court to ensure that the individual adheres strictly to all imposed restrictions. They did their thing. Michael, president of RSEC Group. The president of this team and this company. All right. I like it. I like it. I like it. I like it. We're gonna get into this other indictment. We're still on Little Dirk, people. We're gonna get on this for a second, but I'll tell you why I like it. I think it was thorough. Thorough. It was. They knocked down how severe the charges and the evidence still is against him, the bond package, the security agency, um, you're showing that there was areas of conceding or concession from the government by the things that they took out the original indictment. I like it. I'm still gonna keep him getting no. I'm gonna move it up. I'm gonna put his bond for me after looking at what they presented, what he got on the table now. I'm gonna move his bond percentage up to 60%. 60% he gets it, 40% he doesn't. As far as getting the superseding or the original indictment thrown out because of the grand jury stuff, the 0%. It's not happening. They're taking Dirk to trial. They're not throwing out nothing. But all right, we'll see. Now here's an issue. So that was the good. Now let's go to the bad. Here's an issue. Remember when Dirk got arrested, when he got picked up on his way or at the airport from Florida, and they were trying to say that it looked like he was about to do the race. When they had him in custody, like a couple days later, they unsealed another indictment that was like from a year and a half prior, related to what they are alleged another murder for hire. The retaliation shooting for his brother D thing, right? Remember that at the youth center? That indictment was wild. They pulled up over there, they hopped out, long guns, and it went the way it went. But here we are now coming back to that. This was filed 2 days ago, right? So this case for Preston Powell, aka also known as Marley, I believe this is one of the alleged shooters in that case, right? This is being tried out of Illinois, whereas Dirk's case is out of California. The scary thing about this is if it's a murder for hire, of course, you don't want, as this is ongoing, anything to come up related to Dirk. Now, the first thing I did in here was I typed in Dirk in a search, and he doesn't come up right now in this, which is good for Dirk. Good for Dirk, right? But it's still all alleged as per when that was unsealed that Dirk sent this. And this is the problem. This is what's going to continue to come out. What did they just get out of the jail cell? What I mean by that? Okay, let's read it. Government's response to defendant's motion for severance. Introduction. On January 27, 2022, defendants Anthony Montgomery Wilson, who was also known as AJ, and Preston Powell, who was also known as Marley, killed Stephen Mack, who was also known as Youngin, outside the youth Peace Center in Roseland to collect a cash payment for his murder. In October 2023, Montgomery Wilson and Powell were charged in the indictment with using a facility of interstate commerce with the intent that a murder for hire be committed and that the death did result in violation of that code, and conspiring with each other to use the facility of interstate commerce with the intent that a murder for hire be committed and that death did result in violation of that code. Now, I'm gonna skim this real quick before we get to the important part. I'm just curious if the exhibit of the guy that was on Instagram flexing money is in this. And I thought that there was videos of them placing Dirk and them in the same room, like separately on a different occasion, like trying to show ties. But I do remember that going around the internet when we first got our hands on this. But I do remember this exhibit here too. That I think they say they got his fingerprints off of the phone that was left in the car, left behind. But anyway, all right, here's where it gets thick. After Mac's murder, but before he was charged in the case, Montgomery Wilson served time in state prison. While in state custody, Montgomery Wilson discussed Mac's murder with his cellmate, who, unbeknownst to Montgomery Wilson, had agreed to assist the government by recording their conversations. Hereafter, the CS, confidential source. As discussed below, during his recorded conversation with the CS, Montgomery Wilson detailed how he and Powell murdered Mac to collect a cash bounty from a Chicago-based rapper, Individual A. Heavy. I told y'all, the first piece was good. This is bad. One of the shooters, alleged shooters, cellmate, was working was working and recording. You can't talk to your bunkie these days, neither, people. And you allegedly confessed to him while he's working with the government that a well-known Chicago-based rapper is the one that paid you. Individual A. Who is Individual A? A lot of people would take a guess. Powell has moved to sever his trial from Montgomery Wilson's trial. Powell contends that severance is necessary because Montgomery Wilson's recorded statements to the CS, which the government intends to introduce at trial, are inadmissible against him as a violation of the Sixth Amendment confrontation right. So divide and conquer. And at this point, they're also dividing themselves. You know, one of the shooters, yeah, you got two of the shooters in custody. One of them is talking to a confidential informant or a confidential source in his cell. The other one finds out and says, look, man, I want severance of our case. I don't want us together on this, tried together on this, because that situation that's going on over there, that's violating me over here. I don't got nothing. Like, I would want my lawyer to play that as well. The fuck y'all got going on over there? Now you trying to tell me that there's some recordings that's going to implement me over here too? Wow. So they're looking for severance. Factual background, murder of Stephen Mack. We know about those details. This looks like a lot of stuff that was in the original indictment that we already broke down months ago. Yeah. And then there's also like text messages and stuff of them trying to collect the payment and everything. This is bad. This doesn't look good for Durk right here. I'll leave it at that.